It is time to check in with Chris Dimakos, our CJAD 800 legal contributor. And Chris, we're following up on a kind of a theme we've dealt with for a little while now, this idea of employees, employers. You raise an interesting sort of case here. Employers have long believed that if they offer a generous severance package, they therefore don't need to necessarily be honest about the reason for termination in the first place. You're suggesting that may have been the case back then. It's not the case anymore, and courts are picking up on that. So what are we talking about here?
Yeah, and I think it's important for people to understand one major principle is that when you are fired without cause, there's no legal grounds to let you go, the employer does, that's when they have to pay you severance, right? They weren't justified in doing so. But sometimes employers say, well, if we're going to pay a high severance, if we're going to give them, on the upper echelon of the 1 to 4 weeks, we're going to give you 3.5 weeks. We can just write whatever we want as a reason. They're getting the max anyways. Why bother? Well, a recent judgment here, right out of Montreal, where a VP of sales was hired, was getting paid over $500,000 a year, was hired on board. The company grows record sales. They've never had as much sales ever as they did when they hired this individual. 3.5 years into the contract, the company feels like, we squeezed everything we can out of this one, so we're just going to let him go. And when they let him go, they offered him 3.7 weeks per year, which is close to the max. And they were very, very ambiguous about why, the reason. When lawyers got involved, they were avoiding and saying, who cares what the reason is? We're giving you close to the max. Just take it and be happy and move on. So they went to court, and the court said, look, when you are being ambiguous about that, it's very difficult for the employee to then go and get another job, especially when they're high profile,
right?
And they're getting paid that much, because the new employers are going to say, well, why were you let go from your previous company? And if he can't answer that, well, they're going to assume the worst. So it's important that the company is transparent and they tell you why they're letting you go. And even if that reason is, well, we've basically maximized what we can out of you and we don't think you can bring it to the table, well, then put that down as the reason and let that employee use it when they go and try and find another job. So in this case, the courts are like, look, yes, you guys might have offered what is considered to be a generous severance package, but you didn't help him at all when it came to securing a new job, and that's the whole point of severance. So they ordered moral damages, they ordered abuse of process damages. It was a huge judgment in this employee's favor, and what the court basically said is, look, you should be able to let the employee know exactly why they're being let go, and that can help them in their process in finding a new job. And sometimes that might not be easy for you to do, but at the same time, it's what has to happen. Because when you're ambiguous, when you don't give them reasons, well, then they're left trying to explain to new prospective employers
right.
what went wrong.
I guess my question as you outline this specific case is, what led this employee, you mentioned he was getting just about the max that he would have been entitled to for severance. What led him to simply say, well, you make it, I don't know what the top is, 4% if he was getting 3.7, and simply say, well, make that and we'll call it a day? Like, how did this end up even in court?
That's a great question. So what happened was he asked for a letter of recommendation. And the employer says, I'm not doing that. And he said, please, can I have one? I mean, I'm going to be going after high-profile employers. Like, I have a high-profile job. I'm getting paid over $500,000 a year. I need at least a recommendation letter. And they're like, no, we're going to shoot ourselves in the foot if we say what a great employee you were. That can come back to haunt us if you go to court. So over this little thing of a recommendation letter, he went and secured legal counsel. They looked at it, and his attorneys, rightfully so, said, they're not playing fair here. They're not being equitable. Yes, the severance is part of it, but you should be able to get additional damages because of the way the employer is treating it. Not to mention the fact that, the 3.5 years in, it was almost impossible for him, and it was, to find another job with the same salary within that short amount of time. So the court looked at the fact that he did eventually get a new job for half the salary, and they compensated him that for as well. So the point being is, sometimes you'll be fighting over something that seems trivial, like a recommendation letter, which could have solved everything, but it ended up costing the company six figures because of this little point of a recommendation letter.
I was almost going to say, you know what, it would have been easier for the employer, not that they're looking for an out here, to simply say, well, we had this criteria, we feel it was not met, and therefore we're letting you go, pay him a severance, and it's all done.
Yeah, and that's, in my experience, one of the major, I would call it the setbacks that people have, whether you're an employer or an employee, if you're ever in this position, everybody wants to know who's right and who's wrong. And it applies not only to employment, it applies to divorce and family, it applies to commercial disputes. Everybody wants to be right, and everybody doesn't want to be wrong. And sometimes they lose sight of, well, what does that cost me? Being right, what is that going to cost me? And how am I going to finance my life if I'm going to go through a year and a half of court proceedings?
Right.
Who's going to pay for my mortgage? Is employment insurance enough? There are many questions that you have to ask yourself before you get into one of these battles. And in this case, it worked out for the employee, but the employer probably should have sat down with their legal team and said, look, he wants a recommendation letter. If this thing doesn't work out, if we stand our ground on this and we don't concede this recommendation, how bad can this be? And what's it going to cost us in legal fees if it goes to court? How long are we going to be tied up with this? What are we going to have to reveal in terms of subpoena documents? All of these things should be discussed before you get into a non-negotiation hard stance on a certain point. You have to understand what's on the other side of this if it doesn't work out, because so many people say, no, it's the principle of the matter here. We're going to go all the way. Well, understand what all the way means and what all the way costs.
As you're describing it, it seems the company got some bad advice here. I don't know if they even sought legal counsel. They probably didn't realize this was an issue, right? We're simply not going to give you. You worked for us. You want a letter of recommendation. We're not going to give you one. Had they sought legal counsel, that might have changed.
Yeah, this was a public traded company. This is a massive company, and they definitely had legal counsel. What I believe happened here was, I believe that the company and their legal team said, we're being generous here. You should just be grateful for what we're giving you. And I felt that, reading over the case here, they might have been surprised that the court said, you know what? Yeah, maybe you were generous on this point, but you didn't help him out when it came to these other things,
right.
Like, giving him a reference letter, recommendation letter, and allowing him to go and secure new employment. You made it more difficult for him. So that negates a little bit how generous you were on the severance package. So, they had legal counsel. I just think that they miscalculated how much of an impact, being stubborn on certain points ended up being when it came to court.
Yeah, which is why they should have called you. I would just ask one or point out one other thing here. We always talk about, I always bring this up whenever we do stories like this, about when you, as the employee in this case, should actually seek legal counsel. I mean, you have your one-time expense if you're going to do it, but you find out at the end of the day, look how much more you ended up with in a case like this, which you wouldn't have known if you'd had simply accepted the amount and said, well, it's almost the max I should be getting. I'm happy with that.
Right. I always say this. Lawyers are great at giving you the information, and obviously the clients and the employees, they're the ones that end up making the decisions on what they're capable of and what they can't and what the risks are. And what you have to rely on so much, I say this all the time, is experience. People who have done this, people who have been down this road before, what happened with them? And when you start to hear, there's been 50 cases like this, and in 48 of them, it ended up like this, well, then you start understanding what the risks are and whether it's worth going for that extra little bit. So all of these things, which are not textbooks and laws and jurisprudence, they're more life and how much it costs and what the probabilities are, and there's so many variables. So it's a real strategy session that you should be having about what you should go for and what the risks are and what you're willing to concede.
And then you make that decision on your own based on that information. Just the last thing I will ask, maybe it's not a fair question. Are you finding courts now sort of leaning more this way towards the employee, or is that unfair?
No, I'll tell you, I find that what the courts are really stressing now more than ever is they want transparency. What they're saying is, look, there's a lot of technology out there. There's AI. There's all these things. What people are entitled to is transparency. And I find they really come down hard when a company is not being transparent.
Okay.
That seems to me to be the point right now, the trend.
Chris Dimakos, our CJAD 800 legal contributor. Chris, thank you so much. Appreciate it.
I'm Luke Wilson. Join me each week for Film Never Lies. Since retiring from the NFL, I've had a lot on my mind, and now I've got my own show. So if you're tired of lazy takes, if you want honest conversations, join us each week. Film Never Lies, available on all TSN platforms and the iHeartRadio app.